Welcome to Meet the Thought Leader with Katrina Rogers Consulting.
Hi there, everyone, and welcome to Meet the Thought Leader on Thinking Cat. I'm your host, Katrina Rogers, and today we are meeting patent professional Allison Glasunow, partner at Perkins Coie. With a PhD in pathology and years of experience as an interdisciplinary research scientist, Allie focuses her practice on life sciences, biotechnology, and medical device intellectual property protection. Her work includes patent prosecution, portfolio development and strategy, freedom to operate analytics and due diligence, and post-grant review. And she has unique expertise in cell and gene therapies. Today, we'll learn from her about the top legal pitfalls for startups. But first, here's a quick message from our sponsor. I work daily to bring you new insights and help diverse life science entrepreneurs break through obstacles to get their medical products from bench to bedside. Please help me to help you by subscribing to and sharing the Thinking Cat newsletter. Thank you for joining us today, Allie.
Thank you for having me.
Well, you're more than welcome. Why don't we start by having you tell us about your background and your work?
Yeah, happy to. So thank you for the introduction. My background, as you noted, is a little bit different. I started out as a researcher. My plan was to go all the way into professorship at an academic institution. During my postdoctoral studies at Seattle Children's, that pivoted quite a bit. So I had the pleasure of working on some fantastic cutting edge technologies. As that process evolved, I also learned a lot about the business side, and I started to explore, how does one start a company? What does it truly mean to be a startup in the life sciences and biotech? And I think I got bit by the entrepreneurial bug a bit more than I thought I would. But I wasn't really ready to start my own company. Today, I don't think I am either. That part hasn't changed. But I got really interested in more of the aspects of business, right? And how does one do this? My first kind of segue into that was through IP and the patent system, through a lot of the technology that I was working on at Seattle Children's. And so I decided to take a position with a firm called Wilson Sonsini, Goodrich and Rosati, about 13 years ago now, very early. So as the job title is called a technical advisor. And so I came in as a scientific expert who was there to help support attorneys who maybe didn't have the specific expertise in the exact case that was being challenged at the patent office. And so I had fantastic on-the-job training, was exposed to attorneys of all different types of practices and different backgrounds, variety of different clients, and very quickly realized that it was something that I wanted to commit to. So studied for the patent bar, which is a certification effectively and a member of the bar at the patent office. You can practice as a patent agent at that point. So I did that for a number of years and then decided I was going to go to law school. So I worked my way through law school and ended up being recruited to Perkins in 2016, minus like a 2-year hiatus going in-house to a pre-IPO startup. I've been here ever since and been building my practice ever since. My work, as you mentioned, is largely around building patent portfolios, and that includes strategy, prosecution, and then a lot of the logistics that go into asserting them or making sure that there's kind of safety in the competitive space. So freedom to operate and validity and non-infringement. My work spans companies of all shapes and sizes. I would say my sweet spot and where I like to be is in the startup phase. I like to be with companies about seed Series A. You really get to know people. I was just with a client today and we all sat around their table and had lunch, everybody from the logistics team all the way through the C-suite, and it was amazing. And for me, that bond and that connection with my clients, understanding their business is really, I think, key to being successful with them.
Perfect. That sounds wonderful. So what are you working on right now?
Well, I would say the bulk of my clients kind of take two flavors right now. We have, in the life sciences space, there's a large shift toward platform technologies. And so we see kind of a lot of companies that have maybe a hub and spoke model where their platform is the core hub and it's powering and spinning out a number of therapeutics or potential therapeutics. And so we're protecting those companies as a platform company, but then also protecting the separate assets as they go into clinical. And so it's shifting a bit where I think historically it's been one target, one lead, one disease, and then build the second. Whereas now technology is rapidly evolving and pushing people in a place where they can have these really useful platforms and take a variety of different angles with them and to do it rather quickly. So I have clients doing that in small molecule space, a lot of peptides, folks doing a lot of peptides and proteins. And then on the other side of that is a lot of AI-informed technology. I'm a biologist by training. I do not pretend to be a computer scientist or software. I somewhat like to joke that I'm the one that can't install a printer driver. Like technology in me does not work. So the fact that AI is so pervasive and I'm in a place where not only do I have to understand it, but I want to understand it, and starting to really appreciate how quickly it is changing innovation, particularly in clients where they're in drug development, right? We're shortening that initial time frame to lead compounds. We're shortening the amount of capital that's required to get to those lead compounds, and hopefully increasing the chance of success that there is something therapeutically effective at the end of the path for those people. So for me, those are I think the two major angles that I'm working on, and probably the level of specificity that I can talk about. But we also have a fantastic litigation going, and that one's public, so I can share a bit more. One of our clients is on the brand side, and it is a skinny label litigation where there's an indication that a generic has carved out that's off patent. And it's a case that I think is kind of testing some of the boundaries of what generics are allowed to do, not just with skin and labeling, but more in post marketing. And we've been in the state court system. We're now in the federal court system, remanded back to the state. And then there was a writ filed to the Supreme Court. So the Supreme Court will be considering whether they'll take the case up in the fall.
That's very exciting. And I have to say that the areas that you're practicing in sound very exciting to me as well. I think Washington State, where we both live, is really a hotbed of what is traditionally called, or maybe traditionally, right, in the last 6 months, tech.
Indeed. I mean, Washington's a hub for tech, and it's a hub for bio, and seeing the two kind of intersect in this really elegant and powerful way is more than exciting. Plus, we have a Nobel laureate in the state on this space too. So I think we're very, very well equipped with some very impactful folks.
Indeed. And the laureate that Ali is referring to is Professor David Baker at the University of Washington. Awesome. So let's get down to some brass tacks here. What are the areas of law that life science startups should pay attention to?
Yeah, it's a good question. I tend to, I mean, the three things that folks in life sciences startups generally should be aware of are early stage corporate and investing, right? Ensuring that you're forming the right type of company and doing it in such a way that you're attracting investors, right? The difference between an LLC and a C Corp, making sure you're doing it in the right state, making sure you're up to date with your filings in that state, that you've got your cap table structured appropriately, and that you've got it structured appropriately for growth, right? For growth, for investors to take an interest, and for the company to recruit top talent. There's a handful of things on the corporate side, I suppose, where if they get missed or go wrong, can be fixed. It's costly to do it, right? To fix it, but it can be fixed. I think the thing that really hangs startups up is this tension between needing to talk about what you're doing, right? To gain interest and to get investors, to get some hype going, to get collaborators, but also not necessarily having the patent protection in place to go out and have those conversations. A lot of early stage companies haven't yet filed their first patent applications or haven't filed robust patent applications on these topics that they need to start marketing themselves on. The challenge there is one of the phases where you can't put the toothpaste back in the tube. Once it's out, it's out. And it can be catastrophic for companies. And so I think engaging with IP and coming up with a patent strategy, at least getting some input from patent counsel about, hey, we want to submit this manuscript. We need to present at a conference. We want to submit a press release. So we're going to do a glimpse of our product on Instagram, whatever it may be. Getting patent attorney to take a look at that and at least give you some idea of how risky is it, right? Is it a risk tolerance that as a business decision, the company can make and can come to terms with, right? Sometimes, right, I tend to say I don't like to have IP drive company strategy, right? But there's also an element of where it has to align with company strategy. And there's a give and take element there. A lot of startups, especially first-time founders, aren't aware of that, right? They don't necessarily know that they're creating those issues for themselves. So I think getting into that in an earliest stage is important. Biotech, and particularly the more complicated therapeutics that we have today, these so-called advanced therapeutics, where say we're taking a stem cell, we're differentiating it, we're gene editing it, it's expressing something different, it's got a knockout, and now it's a therapeutic for a patient, right? That is extraordinarily complex product, and usually a lot of hands and entities touch it along the way. What hangs people up often that we find, especially as you get closer to regulatory or investment, is the provenance of materials. Have you used something along the way that had a research use only license? Did you get a commercial use license at the right time? Did some vector that you're borrowing part of an AAV or a viral capsid, some sort of a viral entity from, did that come from, an academic investigator down the hall who's a great friend and happy to share resources? Did that get roped into a potentially commercial product? And so understanding where every little piece is coming from and the rights and limitations that exist with respect to that piece. Where that kind of can trip people up is if you end up in, let's say, getting ready to go to phase 1 clinical trial, and you say you've got a viral vector that did come from somebody down the hall, the university may have a claim to that. And so you may have to go back and start from scratch or negotiate a license, and that can really surprise folks. I think the last thing with that is the other thing that's overlooked is the importance of, at least with IP, the importance of inventorship and ownership of IP, making sure you've got your employees that are signing their inventorship agreements when they're onboarding, and understanding if those employees have, let's say, a co-appointment at a university and an obligation to assign IP, right? And how do you divide? How do you divide where the IP goes, company or university? Sometimes folks think they're making the right decision and proceed on, and then, months or years later, they find out that maybe there was information that was missing along the way. And so just asking questions, knowing the right questions to ask, I think is key when it comes to provenance, public disclosures, and then inventorship ownership.
You've given us a lot to think about, and you've already answered my second question, which is most often overlooked. When we talk about intellectual property, do you generally advise on other types of intellectual property besides patent protection? Sometimes small companies don't have a lot of money to put into patents.
Yeah, I certainly do. So the bulk of what I do is patents, but there's a kind of a give and take with the patent system. The flip side of it is trade secret protection. So we advise on perhaps what sort of components of the technology or aspects of the company would be better off being protected by trade secret, whether that's in the near term or the long term. And then we do some advising on trademarks overall. Is, are folks considering trademarks, and are they considering them us or globally? Same with the patent system, right? Are thinking about where they commercialize, whether it's the US, so there's a global element to it. And so how to build portfolios that are robust for today's market, which is not just the area where a company exists, but usually far broader than that.
I'm glad you also mentioned agreements with your employees and your gig workers and the other people that you work with, because I believe there's a very a brand new announcement out in the press today about a fairly big lawsuit being brought by one pharma company against another about what information was passed by a former employee. So I think that's going to be a very interesting thing for us to watch here in the news.
Yeah, I think it is. And, there was some safeguard, I think, a bit before that with non-competes, right? Certain employees who may have had that information had a period of time before they could go to a competitor. And non-competes aren't really as powerful as they used to be. And then some states are outright unenforceable. So the risk for that kind of information leak, I think, is far greater today than it used to be. But I think it's there's something key there about, when you're in these R&D phases and you're hiring folks, right? There's a lot of turnover. Life sciences at early stages volatile, even bigger stages is volatile. People move around. And so just, again, asking questions, right? Asking people about, tell the story, right? Tell me how you came up with this idea. Let's explore what you were doing, and really kind of digging into that. And that doesn't have to be with a lawyer, right? That's all within company. And I think most folks that are kind of in that space have at least a bit of awareness to understand, this is kind of toeing the line. Maybe this is something we need to dig into further.
Right. Right. One piece of advice that I've received was that when you're actually going out to do commercial manufacturing, or you're working with partners, because we do a lot of work with contract manufacturers or contract research organizations. Yeah. When you go out to them and they're using some technology of their own, or they're providing some information, that when you ink a deal with an organization like that, that you have some claim to to the technology as you validate your process, because that's a significant part of the ultimate filing that you're going to put in. And if they have control over it, that could create a great problem for you down the road.
Yeah. There's a couple different ways folks do that. You can do that, with a license to use that part for your particular technology and manufacturing needs. Where it can get kind of sticky is if the person or the entity that is submitting whatever it is that's being manufactured and having this proprietary system applied to it. Let's say you give some feedback, right? Let's say whatever it is, sterile fill finish, you name it, right? You need to change flow rate of something, or maybe suggest a reformulation because there's a challenge with something precipitating out. You can get into a situation where there's IP there, and now you've got two entities that are coming up with it together. I will say it's not uncommon, right? You put a bunch of smart people together to again, these complex products, right? And you've got a lot of smart people along the pipeline there. And you put them together, they're innovative, they're thinking through this, and the chances that IP is going to be sometimes can be quite high. And so negotiating that, right? Like when you're doing these agreements, having a joint IP clause in there and pre-discussing, like in the event this does occur, how do we treat that, right? How do we split that within the company? Who's going to control it? How are the licenses going to go? Who's got the right to use it when? Can you sub-license it to another party, right? Could they use it with potential competitor? So there's a lot of scenarios to walk through that I think are, again, something, I think back to one of your questions on things that are overlooked, right? Something that's overlooked and thinking down the line, really, right? I think a lot of startups are very focused on the here and now, which is excellent, right? They have to be, but also realizing, hey, we could be really successful, right? And what happens in 5 years when we are, right? And we're taking more market share, we're growing, we're scaling, we're involving more of these organizations and trying to kind of think proactively as much as you can about those different scenarios before you get into them.
Sure. Well, and it could create a lot of drama when you go to ink a deal with a strategic too, which of course for many small pharma companies, that's what they're looking for.
Absolutely. And that's where we see that kind of rear its ugly head, so to speak, is when those larger partners are wanting to see those agreements, right? Are they what obligations would transfer to them? What things can they do and cannot do?
Well, I think you've just demonstrated your enormous value as even just a thought partner in this process. And one of the things I'm grateful for is you mentioned that these challenges can be fixed, but it will cost money. But it's not as if the thing is horribly broken and will never be fixable again, unless, of course, you let your intellectual property leak out. So.
Yeah. There can be some creative solutions, but they're usually not going to get you back to square one on the IP front, I'm afraid.
Right. Okay. In April, you spoke about startup law at an innovators boot camp in Spokane. Do you have any other upcoming events we should know about?
Yeah, so I have that one in April. I believe it's April 15th. And that one is myself and two other colleagues, where we're going to spend 8 hours diving into all things for innovators in the startup space. So intellectual property, early stage corporate matters, and then some licensing and agreement subject matter. We're doing the same thing the following day in Missoula, same set of colleagues. So we'll be kind of trying to cover the area, so to speak, in that space. Aside from that, you'll see us at Bio. We're sponsoring some events at Bio, and we'll be in Boston for the week there for those events and kind of in the ecosystem, so to speak, with, I don't know, 50,000 other people. But it's such a conference. It's a conference full of so much information and great access for folks. So we're looking forward to being there.
It sure is. Well, good. Hopefully I'll get a chance to catch up with you. And I hope you've booked your rooms already. I understand that if you don't book them now, you can run into troubles at that point later on. So
that is true. Yeah. And I managed to. Did not get them before the bio rates kicked in, but I did get a room.
Good plan. So if people want to chat further with you, maybe on a more privately basis, how could they reach out to you?
Yeah, so I think the easiest place to reach me these days is either, the most public place is through LinkedIn. I'm searchable on LinkedIn, and you can find me there. And then also through contacting or looking on the Perkins Coie website, you'll see my office phone number and my email address. I can provide those in the summary or however you wish to, but I think those are probably the two easiest places.
Excellent. Well, I'll put your LinkedIn URL as well as the Perkins Coie URL on the material that will accompany this video, so people will have a chance to look that up. Nobody has to scribble anything down here.
Sounds good.
Very much for sharing your expertise with us today, Allie.
Yeah, my pleasure. Thank you for having me.
Awesome. Listeners, Allie will join me on the Thinking Cat Chat 1 week from Friday. Don't miss your chance to ask her your life science intellectual property questions.
Thanks for watching. Don't forget to like, share, and subscribe for more tips on navigating the life science industry.